So, good day guys. Again, welcome to our YouTube channel. So, this day we'll just continue our discussion on the subject criminal justice system, specifically the law enforcement pillar. So, one of the functions of law enforcement pillar is the conduct of search and seizure, wherein search is defined as the act of looking carefully in order to find some concealed items. On the other hand, seizure is the taking of something into custody, meaning this activity, the search and seizure, is a procedure conducted by police or other law enforcement authorities and their agents wherein they commence to search a person's property and confiscate any relevant evidence found in connection to the crime and surrender or take it in the proper custody. And as a general rule, every search and seizure must be done by virtue of a search warrant. And search warrant defined under Section 1, Rule 126 of the Rules of Court as an order in writing issued in the name of the people of the Philippines, signed by the judge, and directed to a peace officer, commanding him to search for personal property described therein and bring it before the court. And as mandated by the Philippine Constitution, which is considered as the supreme law of the land, every people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall be issued without these following requisites. So what are the requisites of a valid search warrant? First, a valid search warrant shall be issued upon probable cause. When we say probable cause, it refers to such facts and circumstances which would lead a reasonably discreet and prudent man to believe that an offense has been committed and that the object sought in connection with the offense are in the place sought to be searched. Second, such probable cause is determined personally by the judge upon examination under oath or affirmation of the complainant and the witnesses he may produce. And third requisite is that the valid search warrant must particularly describe the things and place to be searched. This means that if the place to be subjected for search is in the living room, the officers conducting the search shall only be limited to search the living room and not on the other parts of the house, and only the specified things shall be subjected for seizure. But objects that are considered illegal, even if not particularly described in the search warrant, may be seized under the so-called plain view doctrine. And furthermore, the Supreme Court ruled out that the place to be searched as set out in the warrant cannot be amplified or modified by the officer's own personal knowledge of the premises or the evidence they adduce in support of their application for the warrant. The particularization of the description of the place to be searched may properly be done only by the judge and only in the warrant itself. It cannot be left to the discretion of the police officers conducting the search. And under Section 3, Rule 126 of the Rules of Court, the properties subject of search and seizure are only personal properties. When we say personal properties, these are those properties which can be transferred from one place to another, like for example, the ammunitions, the firearms, clothes, and the like. So what are the subjects of a search warrant? First, the subject of the offense. These are properties, for example, in selling of dangerous or illegal drugs, which is the violation of RA 9165 or the Comprehensive Dangerous Drugs Act of 2002. The property or properties to be subjected for search and seizure is the illegal or dangerous drugs itself. Second subject of the search warrant is the stolen or embezzled and other proceeds or fruits of the offense. Example of these are the jewelries that was robbed. Third one is the use or intended to be used as a means of committing a crime. Example, the firearm that was used in killing the victim. So next, how about the validity or the lifespan of a search warrant? So under Section 10, Rule 126 of the Rules of Court, a search warrant shall be valid within 10 days from its date. So this means if in the implementation of the search warrant, its object or purpose cannot be accomplished in one day, the search can be continued the following day or days until completed, provided it is still within the 10-day validity period of the search warrant. Thereafter, it shall be void. So, when to serve a search warrant? As a general rule also, the warrant should be served during daytime unless there is provision in the warrant allowing service at any time of the day or night. So, as I mentioned before, as a general rule, before every search and seizure must be done by virtue of a search warrant. But as we always say that in every general rule, there are always an exemptions, and the exemption to this rule include the following. So first is the so-called consented search. So under consented search, the person is willing to submit himself for a search despite of no warrant presented, or the right against unreasonable search and seizure may be voluntarily waived by a person being searched. So when can we say that there is valid waiver of the right or there is consented search and seizure? So when a citizen waives his or her right and consent to the search and seizure, the police officer must ascertain that he, in the first place, know that he has such a right before he can relinquish it. Example of consented search is that if a certain citizen, knowing his right against unreasonable search and seizure, still voluntarily allow the officers to search his belongings and surrender his or her gun, therefore, he cannot claim illegality of the search and seizure. So, next, warrantless search and seizure can also be conducted on a person lawfully arrested, and this is called the search incidental to a lawful arrest. So in this case, the person can be subjected to search without a warrant, and the police have the right to make a contemporaneous search in the arrested person for the fruits or of tools used to commit the crime. This includes all the things under the arrested person's immediate control and the extent, depending on the circumstances of the case, to the place where he is arrested, may also be subjected for search. That's why if the accused was arrested while inside a jeepney, there is no valid search incidental to a valid arrest if she will be brought to her residence and thereafter search the said place. Then, an illegal things at site may be seized by a police officer even without a warrant to do so, and this is known as the plain view search or the plain view doctrine. Under this kind of search, the things must be readily seen without any effort of locating it, meaning the police did not exert effort in looking for the contraband. It came accidentally to his view. So the elements of plain view search or plain view doctrine are the following. First, a prior valid intrusion based on the valid warrantless arrest in which the police are legally present in the pursuit of their official duties. This means that the police and the other concerned agencies must have prior justification for an intrusion. He or she is not a trespasser, or otherwise must be in a position from which he or she can view a particular area. Second element is that the evidence was inadvertently discovered by the police, who had the right to be there where they are, meaning the discovery of the evidence in plain view is unintentional or it was discovered by chance. Next, it is immediately apparent to the officer that the item you observe may be evidence of a crime, contraband, or is otherwise subject to seizure, and the evidence must be seized without further search. So, other one that is considered as a warrantless search is the search of a moving vehicle, or commonly known to as a checkpoint. As a rule, a search made in checkpoints shall be limited to visual search only, and neither the vehicle nor the occupants shall be subjected to physical search or require the passengers to alight from the vehicle. Then we have the custom search. So persons exercising authority under the customs law, specifically personnel of Bureau of Customs, may effect search and seizure without a search warrant to regulate exports and imports. Meaning, a search and seizure may be made even without a warrant for the purposes of enforcing custom and tariff laws. And last one, we have the stop and freeze. So in stop and freeze situation, or known as the Terry search, that was derived from the United States, is a case, the landmark case named Terry versus Ohio. Under this kind of search, when a police officer has a reasonable suspicion that an individual is armed, engaged, or about to engage in a criminal conduct, the officer may briefly stop an individual and can be subjected for search, but limited only on pat-down search of outer clothing. So, if the security guard in a mall wants to open the bag and check the inside thereof, isn't there a violation of the right against unreasonable search and seizure? So the answer is no. There is no violation of the right. Private search is not covered by the constitutional guarantee. In the case of People versus Marty, the Supreme Court rationated that in the absence of governmental interference, the constitutional right against unreasonable search and seizure cannot invoke against the state. So the protection against unreasonable search and seizure cannot be extended to acts committed by private individuals, so as to bring it within the ambit of alleged unlawful intrusion by the government. So what is the distinction between warrant of arrest and search warrant? So first, both the warrant of arrest and search warrant are orders in writing issued in the name of the people of the Philippines, signed by a judge, and directed to a peace officer. And they are issued only upon probable cause. Second one is that the warrant of arrest is intended to arrest a person, while search warrant is intended to search and seize things specified therein. So, another difference is that the warrant of arrest remains valid as long as the person stated therein is not arrested, regardless of the number of days that already lapsed, while a search warrant is valid within 10 days from the issue. Then next is that the warrant of arrest may not be in possession of the arresting person when conducting arrest, while the search warrant must be in possession of the police officer when conducting search and seizure. And last one is that the warrant of arrest may be executed any time of the day and night, while search warrant as a rule must be executed only during daytime. So that's it for today, and thank you and God bless.